How long you been there?
That's the company. Now, there's a lot of TIC. You go to Home Depot and get those orange buckets. That's his company. Hi, John. How are you, buddy?
Oh, okay. Yeah, he looked a little familiar.
Where do you live?
I live in Canada.
Yeah, where?
In Canada, Nova subdivision.
We're over. He's on Erie, and I'm in Illinois. I'm over by Telegraph and Voorhees.
Oh, okay. I used to live in the Indian Village over there. As a matter of fact, I used to live on West Iroquois in the Nominee.
Okay.
Second house after the corner over there.
I can just a trip over here, taking a
Yeah,
walk.
that was way back there in the 70s.
Wow.
In the 70s.
All right.
Now, like you say, one of you, we're going to have to make a nomination for one of you. Which one of you want to be the secretary?
Well, nominate David. No. I'm going to nominate you, Vince. All right, I'll be the secretary.
And the correct pronunciation of the last name is correct.
Say or with a list. Perfect.
Raise your right hand. Repeat after me. I do solemnly swear or affirm that I will support the Constitution of the United States of America Charter of the City of Pontiac, Michigan,
and the Charter of the City of Pontiac, Michigan,
and that I will discharge the duties of
and that I will discharge the duties of
Medical Marijuana Commission Member
Medical Marijuana Commission Member
of the City of Pontiac, Michigan,
of the City of Pontiac, Michigan,
according to the best of my ability.
according to the best of my abilities.
Oh, I just need to sound like that.
Okay, so I got that.
Good evening, everyone. By my clock, it is 6:01 p.m., and this is the May 12th, 2022 regular meeting of the Medical Marijuana Commission, and I now call this meeting to order. Can we have a roll call?
Ford,
Here.
Wilson, Malley,
Here.
Pratt.
Oh, I guess that was me then, yeah, okay. I'm here.
Oh, I'm sorry, I got it mixed up.
Okay, we have a quorum.
Yeah, go ahead.
We have all members, so we do have an amendment to the agenda. It is a motion to amend the agenda to add a new communication as item 2B. 2B from Anthony Bologna, requesting that the Peer Provisioning Center appeal hearing date be changed from May 26, 2022 to May 19th, 2022. Can I get a motion to amend the agenda?
I move that the agenda be changed, be amended
Okay.
as stated.
Okay. Can I get a second?
Second?
Second. I got a motion from Commissioner Wilson, and who's the second from?
Porath.
Okay. Commissioner Porat. Okay. Roll call.
Wilson.
Here.
Malley,
Here.
Pratt,
Here.
Ford.
Correction. Let's are we getting yeses or?
Yeah.
Yeah.
The motion be yes or no?
Yes, the motion be, were those yeses that I was hearing, or?
I thought I was here.
I thought I heard the word here.
Yeah.
So
I didn't even peek.
just so you know, we're making a motion to approve of this amendment, so we need a yes or no. So can we go through that again?
Go there.
Commissioner?
Wilson.
I don't think he heard you.
Oh, Wilson. I think he just stepped up.
Commissioner Wilson, we're trying
you trying to approve the.
Yeah, we trying to.
to rule on the motion, yes or no?
Yeah.
The motion.
And then Malley,
Yes.
Pratt,
Yes.
Ford.
Yes. Okay. All right. Next item is the
No.
approval.
No, we need.
A motion to approve the agenda as amended.
Yes, that's what I was going to do. Yes, thank you, sir. Appreciate that. Next would be a motion to approve the agenda as amended.
I move to approve the agenda as amended.
Can I get a second? Okay, we got a move by Maley and a second by Wilson. Roll call.
Malley,
Yes.
Pratt,
Yes.
Ford,
Yes.
Wilson.
Yeah.
Next is the approval of the minutes. Can I get a motion to approve the minutes of April 28, 2022?
Motion to approve.
Okay, can I get a second?
I'll second.
Wilson second.
Okay, we got a motion by Porath and a second by Maley. Roll call.
Pratt,
Yes.
Ford,
Yes.
Wilson,
Yeah.
Malley.
Yes.
Okay. And now we're down to agenda items, communications, commission appointment. We've been notified that we have, we no longer have a secretary. And so we do have to appoint a new secretary. So one of the main roles of the secretary will be, for this commission, will be take the roll call at the beginning of our meetings. Can I get a motion to recommend commissioner for the position secretary?
Brother Chair, Paul Wilson.
Just a second, I'm sorry, point of order. Go ahead, Mr.
All
Clerk.
right, Mr. Chair, you're skipping over the communication. You added to the agenda the communication from Mr. Bologna or something?
Yeah, that
As
was,
2B.
we had
That
that
comes before the selection of the secretary.
okay, we have that as 2B, so that will come before this?
Or, yes.
Okay, thank you, sir. My apologies, Commission. We will go to item number 2B, the communication from Anthony Bologna requesting the peer provisioning center appeal hearing date be changed from May 26, 2022 to May 19, 2022.
So you just, I spoke with the city attorney. You just need to receive the communication.
Just receive that, okay, my apologies. We'll receive that into the record. Right. Thank you. Next item is, Commissioners, is now the selection of a secretary, commission secretary. Can I get a motion on recommendations?
I nominate David Bora.
Paul Wilson, second.
Okay. We have a motion to nominate Dave Porritt. It's been second. Roll call?
Ford,
Yes.
Wilson,
Yes.
Maley,
Yes.
Parath.
Yes.
Thank you, sir. And the next item are the discussion on the Walton Boulevard Overlay District Provisioning Center's appeals hearings. First up will be discussion on lake effect, the lake effect appeal. Do we have any discussion from let me just
Yes.
read it. Let me just read something into the record just regarding the appeal, the basis for their appeal. That they stated that they, number one, they say that the appellant provided sufficient material for an award of at least an additional 45 points under the city's ordinance. Two, the scoring in several categories was not based on competent material and substantial evidence. Three, the city's scoring methods are arbitrary, capricious, and based on clearly erroneous findings of fact. Four, the city's scoring under each category was inconsistent across the applicant pool. Five, the city's scoring did not comply with the city's own marijuana ordinance. And six, the city's scoring decision was an abuse of discretion. Okay. Do we have any discussion on this from any of the commissioners?
Yeah, Paul Wilson. The discussion that I, and the reading, I did have an opportunity to review the city ordinance number 2357B. I also had an opportunity to take a look at the city application and the instructions that was in the application that was there. I also had an opportunity to take a look at the scoring metrics, among other things. And in my review of this and looking at it, the original award was, they had 70 points out of 130 to start with. After review by the city, the They were awarded an additional 23 points, which brought the total to 93 points out of 130. A couple of the things that I noted in looking through the material that was there, I looked at that they received the maximum points in several of the areas, which is 10 points in community development. They did receive the 10 points in the finances that was given out. There was an additional 4 points in economic benefit. And as a matter of fact, did have a chance to look at the whole thing and looking at the additional 23 points that was awarded. And the person doing the review of theirs, which was a Chelsea Leonard, I think, and looking at the rewards of the 23 points, I do agree with the 23 points that was awarded. So I agree with the award that was given to the individuals in Lake Effect.
Thank you, sir. Any other commissioners? Anything?
Nope.
Okay. And for me, I'll just put on record that I too, like Commissioner Wilson, I did review the file, and I went by, one of the things I relied upon was the information from the hearing officer, and I looked at the fact that the hearing officer awarded points in this matter, the awarding of 23 points, and so I went back and reviewed the file to see if I found that I was in agreement with the awarding of points, and I found that I did, and so the request was for an additional 45, for a total of 45, but the hearing officer did not award that, and I found that I agree with the findings of the hearing officer. I found that the hearing officer did a thorough review of the information that was presented, that was available, and then the other thing is that the city clerk, after the initial review of the scoring of the application for Lake Effect, the city clerk accepted the recommendation of the hearing officer in awarding the additional points. And so based upon that, I found that the city clerk did not act capriciously or that it was the final awarding of the final scoring of the application was proper. Okay. All right. Hearing nothing else from any other office commissions. Next thing is the resolution on the Lake Effect appeal. And like last meeting, I'm going to read this resolution on Lake Effect, and we will then determine if we're going to take action on it. And if we do, this will determine whether or not the appeal of Lake Effect is approved or denied. Okay. This resolution on Lake Effect appeal to the Medical Marijuana Commission. Whereas in 2018, voters approved the City of Pontiac Medical Marijuana Facilities Ordinance, Ordinance 2357B, and whereas Ordinance 2357B give the city clerk the responsibility to score and rank applications for provisioning centers using a 130-point scoring system and awarding permits to the 20 highest scoring applicants, and whereas the City of Pontiac adopted Ordinance 2363, an ordinance to include medical marijuana facility uses in designated overlay districts, and whereas Ordinance 2363, Section 2.546, Medical Marijuana Provisioning Center, Section F, Licensing, states that no more than 5 provisioning centers shall be established in each of the medical marijuana overlay district, including Cesar Chavez, Walton Boulevard, C-2 downtown overlay districts, and whereas Ordinance 2363 states that no more than 5 provisioning centers shall be established in the C-1, C-3, C-4 zone properties combined outside of the medical marijuana overlay districts. And whereas the city clerk accepted provisioning center applications by overlay districts and the non-overlay for a 21-day period, January 6, 2020, January 6 through 27, 2020. And whereas the city clerk ranked and scored provisioning centers by district using a 130-point scoring system, and whereas the city clerk informed Lake Effect that their application for a provisioning center in the Walton Boulevard overlay district had received a score of 70 and a ranking of 12 of 15 on November 24, 2021, whereas Lake Effect appealed the score and ranking to the city clerk since its application was denied because it was not ranked in the top 5 for the Walton Boulevard overlay district. The city clerk appointed Agreewall Law PLLC to serve as the hearing officer. The hearing officer conducted a hearing on December 17, 2021. The hearing officer issued a recommendation to the city clerk. The city clerk adopted the hearing officer's recommendation. Based on the hearing officer recommendation, Lake Effect ranking changed to 11, but remained not ranked in the top 5. Therefore, the city clerk affirmed his decision to deny Lake Effect application, and whereas ordinance 2357B allows an applicant to further appeal to the Medical Marijuana Commission, and whereas Lake Effect submitted their appeal to the Medical Marijuana Commission on January 23, 2022, and whereas the city attorney issued a recommendation to the Medical Marijuana Commission to deny Lake Effect appeal, and whereas the Medical Marijuana Commission reviewed the Lake Effect appeal and the city attorney's recommendation, now therefore be it resolved, the Medical Marijuana Commission finds no basis to overturn the clerk's decision to deny Lake Effect application for a provisioning center in the Walton Boulevard Overlay District. Okay, and again, Commissioners, by voting, if we approve this resolution, that would be a denial of Lake Effect's appeal. Okay. Can I get a motion to take action on this resolution?
Paul Wilson, I move that the resolution that was just read be accepted by the commission. I
Can I get,
vote to accept the resolution.
can I get a second?
I'll second the motion.
Okay, been moved by Wilson, second by Porret. Mr. Clerk, roll call.
Wilson,
Yes.
Maley,
Yes.
Parath,
Yes.
Ford.
Yes. Next item is item number 6, discussion on Lucid Detroit appeal. And again, I want to just read into the record the basis, what they say the basis for their appeal is. The basis for this appeal is 1, lack of material, competent, and substantial evidence for denial. 2, erroneous and improper denial. 3, arbitrary and capricious findings. 4, applicant's denial was based on unfair/inconsistent review process. 5, review/scoring methods do not comply with the ordinance. And 6, scoring was an abuse of discretion. Do I have any discussion from any of the commissioners on this appeal?
No.
Paul Wilson, there and again, and did take a look at the report that was originally turned in, where they received originally 106.5 out of 130 points. After the review by the hearing officer, on December the 27th. That point total was changed to 120 out of 130 points. When I did look up under facility planning and I reviewed paragraph 9F 2 and 8, and looking at the same material that was referenced there and again, and that was called out in the material for the application process. Did take a look at the material that was called out and what needed to be submitted in the application process. Also took a look at 23.57B, and in looking at the hearing officer's scores and everything, I concur with what the hearing officer did in changing from 106 to 105 original points and awarding on December 27th 120 out of 130 points. Did take a look at all of the additional information and to include the drawings that was there. I agree with the points that was awarded by the hearing officer. Also, apparently the city clerk agreed with the two, because they did change the score from 106.5 to 120 points out of 130 points on December the 27th. So I agree with the findings.
And for me, I like you, Commissioner Wilson, I did go back and review the application. I reviewed the hearing officer's recommendation, which I found to be thorough and what I found to be of note is that, like you, the hearing officer did increase the recommend the point total be increased from 106.5 to 120, which I feel that's a notable increase. But the hearing officer did during this application note several things that was recommended for to be increased, added additional points to. And so I went back and reviewed, looked at those, the reasoning why, and I found that I agreed with the reasoning. And then there were a couple of things that the hearing officer did not agree with. And so I went back and looked at those things to see some of the reasoning for the denial by the hearing officer. And a couple of things was lacking in the information presented, or that should have been presented, and therefore I have no problem. I was in agreement with the findings of the hearing officer. And then I go back to the fact that the city clerk, again, had the opportunity to review the findings of the hearing officer and did adopt the recommendation to increase the final point total for Lucid Detroit. And therefore, based upon that, I feel like the hearing officer did a very thorough review of the appeal. I feel like I did the same thing. I didn't see anything that was arbitrary or capricious in the final decision of the city clerk to adopt the recommendation of the hearing officer. So I'm ready to move on this item, on this appeal. So hearing up, go ahead.
For the chair, I move that the resolution.
Just a second.
Oh.
I'm gonna read the resolution first.
Okay.
Okay. Resolution on Lucid Detroit, appeal to the Medical Marijuana Commission. Whereas in 2018, voters approved the City of Pontiac Medical Marijuana Facilities Ordinance, Ordinance 2357B, and whereas Ordinance 2357B gives the city clerk the responsibility to score and rank applications for provisioning centers using a 130-point scoring system and awarding permits to the 20 highest scoring applicants. And whereas the City of Pontiac adopted Ordinance 2363 an ordinance to include medical marijuana facility uses in designated overlay districts, and whereas ordinance 2363, section 2.546, medical marijuana provisioning center, section F, licensing states that no more than 5 provisioning centers shall be established in each of the medical marijuana overlay districts, including Cesar Chavez, Walton Boulevard, and C-2 downtown overlay districts. And whereas ordinance 2363 states that no more than 5 provisioning centers shall be established in the C-1, C-3, and C-4 zone properties combined outside of the medical marijuana overlay districts. And whereas the city clerk accepted provisioning center applications by overlay districts and the non-overlay for a 21-day period, January 6 through 27, 2020. And whereas the city clerk ranked and scored provisioning centers by district using a 130-point scoring system. And whereas the city clerk informed Lucid Detroit that their application for a provisioning center in the Walton Boulevard overlay district had received a score of 106.5 and a ranking of 7 of 15 on November 24, 2021. Whereas Lucid Detroit appealed the score and ranking to the city clerk since its application was denied because it was not ranked in the top 5 for the Walton Boulevard overlay district. The city clerk appointed Grewal Law PLLC to serve as the hearing officer. The hearing officer conducted a hearing on December 17, 2021. The hearing officer issued a recommendation to the city clerk. The city clerk adopted the hearing officer's recommendation, changing Lucid Detroit ranking from 7 to 5. Based on other appeals in the Walton Boulevard overlay district, Lucid Detroit ranking changed from 5 to 8 and was no longer ranked in the top 5. Therefore, the city clerk denied Lucid Detroit application, and whereas ordinance 2357B allows an applicant to further appeal to the Medical Marijuana Commission, and whereas Lucid Detroit submitted their appeal to the Medical Marijuana Commission on March 2nd, 2022, and whereas the city attorney issued a recommendation to the Medical Marijuana Commission to deny Lucid Detroit appeal, and whereas the Medical Marijuana Commission reviewed Lucid Detroit appeal and the city attorney's recommendation, now therefore be it resolved, the Medical Marijuana Commission finds no basis to overturn the clerk's decision to deny Lucid Detroit application for a provisioning center in the Walton Boulevard overlay district. Can I get a motion to take action on this resolution?
Motion to take action.
Can I get a second?
Second.
Motion been made by Commissioner Porat, second by Commissioner Wilson. Mr. City Clerk, roll call.
Maley,
Yes.
Parath,
Yes.
Ford,
Yes.
Wilson.
Yes.
We're now at item number 8, discussion on the Glacial Waters Ventures Flourish, Michigan appeal. Again, I want to read the basis for their appeal into record. Okay, I want to read the merits in the appeal. The appellant appeals 2 sections. 1, content and sufficiency of information, and 2, community impact. And okay. Do we have any discussion on this item from any commissioners?
No.
Yes, there and again, using the same material that I used for the first two. I happen to note that on November 24th, material that was turned in November 24th, 2021, they scored 106 points out of a total of 130 points. Also noted that when they appealed the process in December, the score was looked at. The hearing officer did review all of the material that was in there. And I think the city attorney did take in consideration the point total was changed from 106 out of 130 points after increasing per the suggestion of the hearing officer. The score was changed to 121 out of a total of 130 points. Then again, using the same process that I had used for the other, and in looking at the same material that was presented in the appeal process, I noted that they were awarded additional points. I noticed that the city clerk did take the award in consideration and increased the points that was given to them. After further reading the total appeal and these resolution that was offered on, I think it was February 25th, 2022, that's when it was appealed to the commission or to this commission on February the 25th. I agree with the write-up that was also given by the hearing officer, and also agree with the process that the city attorney used in coming to his process. He did increase the point total per the suggestion and recommendation.
Thank you, sir. Well, as for me, again, like you, Commissioner Wilson, I did go back and look at the application from the beginning, the scoring, and all the way up to the hearing officer appeal and the recommendations. And like you, I noted that the hearing officer did increase make a recommendation to increase the score from 106 to 121, and that there were several areas where the hearing officer found that there were issues with the initial scoring, such as managerial resources, financial resources, physical improvements. And then there were two areas that were not awarded, such as community impact and facility planning. And so what I did is I went and looked at the hearing officer reasoning why, and why those were not awarded. And a couple of reasons why is basically that information was not directly available to the initial reviewer in the application, and that some documentations were not properly signed or prepared as requested by the requested in the application. And so while I did find that I agreed with the awarding of additional points by the hearing officer, in that the original scoring was not done properly, I do find that the denial of the additional points was proper based upon what I personally saw myself. And again, the recommendation of the hearing officer was submitted to the city clerk, and the city clerk did adopt the recommendation of the hearing officer. And based upon my view that the recommendation and final recommendation of the final point total by the hearing officer, that the review was done properly, and by the city attorney adopting the recommendation, I don't find that the city attorney was acting arbitrary or capricious in coming up with the.
Chairman, I believe you just referenced the city attorney twice, and you meant.
I'm sorry, I did, and I apologize. So
Thank you.
just for the record, I mean the city clerk. I feel that the city clerk did adopt the recommendation of the hearing officer, and therefore I don't feel that the adoption of the final recommendation of the hearing officer by the city clerk was arbitrary or capricious. and therefore I'm ready to move on this appeal. Okay. Hearing nothing else?
No.
I'll read the resolution again, and then I would request a motion to take action. Resolution on Glacial Waters Ventures Flourish, Michigan appeal to the Medical Marijuana Commission. Whereas in 2018, voters approved the City of Pontiac Medical Marijuana Facilities Ordinance, Ordinance 2357B, and whereas Ordinance 2357B gives the city clerk the responsibility to score and rank applications for provisioning centers using a 130-point scoring system and awarding permits to the 20 highest scoring applicants, and whereas the City of Pontiac adopted Ordinance 2363, an ordinance to include medical marijuana facility uses in designated overlay districts, and whereas Ordinance 2363, Section 2.546, Medical Marijuana Provisioning Center, Section F, licensing states that no more than 5 provisioning centers shall be established in each of the medical marijuana overlay districts, including Cesar Chavez, Walton Boulevard, and C-2 Downtown Overlay District. And whereas Ordinance 2363 states that no more than 5 provisioning centers shall be established in the C-1, C-3, and C-4 zone properties combined outside of the medical marijuana overlay district. And whereas the city clerk accepted provisioning center applications by overlay districts and the non-overlay for a 21-day period, January 6 through 27, 2020. And whereas the city clerk ranked and scored provisioning centers by district using a 130-point scoring system. And whereas the city clerk informed Glacial Waters Ventures, Flourish, Michigan, that their application for a provisioning center in the Walton Boulevard Overlay District had received a score of 106 and a ranking 8 of 15 on November 24, 2021, whereas Glacial Waters Ventures, Flourish, Michigan, appealed the score and ranking to the city clerk since this application was denied because it was not ranked in the top 5 for the Walton Boulevard Overlay District. The city clerk appointed Grewal Law, PLLC, to serve as the hearing officer. The hearing officer conducted a hearing on December 17, 2021. The hearing officer issued a recommendation to the city clerk. The city clerk adopted the hearing officer's recommendation, changing Glacial Waters Ventures, Flourish, Michigan ranking from 8 to 4. Based on other appeals in the Walton Boulevard Overlay District, Glacial Waters Ventures, Flourish, Michigan ranking changed from 4 to 6 and was no longer ranked in the top 5. Therefore, the city clerk denied Glacial Waters Ventures, Flourish, Michigan application, and whereas Ordinance 2357B allows an applicant to further appeal to the Medical Marijuana Commission, and whereas Glacial Waters Ventures, Flourish, Michigan submitted their appeal to the Medical Marijuana Commission on February 25, 2022, and whereas the city attorney issued a recommendation to the Medical Marijuana Commission to deny Glacial Waters Ventures, Flourish, Michigan appeal, and whereas the Medical Marijuana Commission reviewed Glacial Waters Ventures, Flourish, Michigan appeal and the city attorney's recommendations, now therefore be it resolved, the Medical Marijuana Commission finds no basis to overturn the clerk's decision to deny Glacial Waters Ventures, Flourish, Michigan application for a provisioning center in the Walton Boulevard Overlay District. Can I get a motion to take action on this?
Motion to take action.
Can I get a second?
Paul Wilson, I second the motion.
Okay, it's been moved by Commissioner Porritt and second by Commissioner Wilson. Roll call.
Prath,
Yes.
Ford,
Yes.
Wilson,
Yes.
Maley.
Yes.
Thank you. Next is item number 10, discussion on nature remedy of Pontiac appeal. Again, for the record, I want to read the basis for their appeal. Basis for appeal. First, as set forth in the, strike that. Okay, I will read this. Basis for appeal. First, as is set forth in the affidavit of Brian Gill, licensed architect from TDG Architects, the hearing officer and city clerk complete survey and site plan. The survey topo was prepared by a licensed surveyor, was signed, sealed by a licensed surveyor, and provided as part of the application. CS 101, the scale diagram was prepared by TDG Architects as part of the application. The scale diagram concept site plan was not required to be signed, sealed, or per ordinance 2357B, section 8C19. Specifically, section 8C19 states that the following must be submitted with the application: a scale diagram illustrating the property upon which the proposed medical marijuana facility is to be operated, including all available parking spaces, and specifying which parking spaces are handicapped accessible. Further, the application instruction states as follows: the applicant scale diagram, section 8C19. The applicant must submit a scale diagram illustrating the property upon which the proposed medical marijuana facility is to be operated, including all available parking spaces, and specifying which parking spaces are handicap accessible. Such scale diagram must be in the form of a property survey prepared by a licensed professional surveyor. And the reference C, Exhibit C, application instructions for section 8C19. As stated by Mr. Gill, section 8C19 really addresses only two very different things, i.e. a survey prepared by licensed surveyor and a scaled site diagram prepared by an architect. Mr. Gill states that both were part of the application, and the site diagram was not required to be signed or sealed, nor should it be. Thus, the ordinance contains an improper condition that a site diagram be signed by a licensed surveyor, when licensed surveyors never prepare, much less sign and seal such a document. For this reason, this part of the ordinance requirement is arbitrary and capricious. Further, the conclusion and findings of the hearing officer and city clerk are thus arbitrary and capricious and not based on competent material and substantial evidence on the whole record, and should be overturned on appeal. The duties of a licensed professional surveyor are outlined in the State of Michigan Occupational Code and Public Act 299 of 1980. Specifically, a professional surveyor means a person who, by reason of knowledge of law, mathematics, physical sciences, and techniques of measuring acquired by professional education and practical experience, is qualified to engage in the practice of professional surveying, MCL section 339.2001. The practice of professional surveying is also defined at MCL section 339.2001F. As such, a surveyor prepares a survey map, plan, report, description, or project, and includes engineering and architectural surveying for design and construction layout of infrastructure. The surveyor engaged in this project will not sign and seal a site plan because that is the province of an architect or professional engineer. Next, the decisions and findings of the hearing officer and city clerk were arbitrary and capricious and not based on competent material and substantial evidence on the whole record, because instead of asking the applicant for clarification on whom authored and submitted documents and what the requirements were for signing and sealing the documents, the hearing officer merely came to an incorrect conclusion because she was confused about whom prepared the documents. This failure to ask for clarification also violates the substantive due process rights of the appellant based on the above cited case law. Thus, the conclusion and findings of the hearing officer and city clerk are arbitrary and capricious and not based on competent material and substantial evidence on the whole record and should be overturned on appeal. Further, as argued in the first appeal, the plain language of the ordinance and application instructions do not require the scale diagram to be signed and sealed, as was the requirement imposed by the hearing officer and city clerk. The submission by the applicant indicates that a scale diagram is submitted and attached in accordance with the actual written requirements of Section 8C19, which contain no obligation for signed and sealed diagrams. The hearing officer and city clerk reviewers have deducted points for a requirement that is not specified in the application instructions nor in the ordinance. As such, the conclusion after the review is not based on competent material and substantial evidence on the record, but is instead arbitrary and capricious. Indeed, inserting the requirement for signing, sealing after the application was submitted with no prior notice is the very definition of arbitrary and capricious and a textbook example of a denial of due process. Last, this is a matter of statutory construction, and the city cannot impose an additional application condition that is not clearly specified in the ordinance. When reviewing an ordinance, the courts apply the same rules applicable to the construction of statutes. Great Lakes Society v. Georgetown Charter Township, 281 Mich. App. 396, 407, 761, NW 2nd, 2D rather, 371 of 2008. The primary goal of statutory interpretation is to give effect to the intent of the law and ordinance, and this is accomplished by examining the plain language of the respective statutes. And Klooster v. Charlevoix, 488, Mich. 289 and 296, 795, NW 2D 578 of 2001. If the intent was to require stamped and sealed scale drawings, then the ordinance would have explicitly imposed this requirement. The applicant clearly provided what was required under the ordinance in order for the hearing officer, city clerk, and other reviewers to properly and fully review the application, which was a scaled drawing illustrating the property, including handicapped accessible spaces. The fact that professional surveyors do not prepare scaled site planning documents and architects do is, again, yet another indication of just how arbitrary and capricious the decision below was. For all the reasons, the conclusions and findings of the hearing officer and city clerk are arbitrary and not based on competent material and substantial evidence on the whole record and should be overturned on appeal. Applicant asks that this Honorable Medical Marijuana Commission overturn the conclusions and findings of the hearing officer and the city clerk and rescore the applicant with a total of 8 points in this category. And then they reference, they listed B, community impact, 5 out of 10 points awarded. And I won't read the entire basis for their appeal. But they conclude that for hearing stated in, the hearing officer recommends that the city clerk modify its decisions on appellant's application by awarding an additional 5 points in the neighborhood land use category. And this will result in a revised total 121 out of 130 total points. Okay? Okay. Do I have anything from any commissioners?
None.
There and again, I took the, Paul Wilson. There and again, I took the application package, reviewed the information that was on page 14 of 31. I also took the 2357B and looking at a couple of different packages. I do see that the hearing officer adjusted the neighborhood land use. He went up from 5 points. He did award an additional 10 points. And in some of the material that I read in those two packages, One of the documents did call out that it's supposed to have been signed and sealed. And in noting, I did note that under that section 9D and the section 8C9, I did notice call outs on one of the applications that called for it to be signed and sealed. I agree with what the hearing officer found and him awarding the neighborhood land use the additional 5 points up from 10. As far as the signed and sealed package that was not signed and sealed, I did see where one of the documents called out for it to be signed and sealed. I agree with the finding that the hearing officer made. I do see that the city clerk changed the point total from 116 out of 130, and he upped it to the additional 5 points that was awarded in neighborhood land use. So I concur with the finding that the hearing officer found.
Okay, for me, again, like you, Commissioner Wilson, I did go back and review the scoring originally and the hearing officer's recommendation. And again, the hearing officer findings were, I thought they were very thorough and very credible, and I found nothing arbitrary or capricious in what I saw, and I felt like the final score was proper for Nature's Remedy of Pontiac, and based upon that, I'm good with the city clerk. I feel like the final score that was adopted by the city clerk is proper and not arbitrary or capricious. And so I'm ready to move on this. I'm ready to move on this item. Okay. All right, hearing nothing else?
You want to read?
Yes.
Now you do the resolution.
Resolution on Nature's Remedy of Pontiac, appeal to the Medical Marijuana Commission. Whereas in 2018, voters approved the City of Pontiac Medical Marijuana Facilities Ordinance, Ordinance 2357B, and whereas Ordinance 2357B gives the city clerk the responsibility to score and rank applications for provisioning centers using a 130-point scoring system and awarding permits to the 20 highest scoring applicants, and whereas the City of Pontiac adopted Ordinance 2363, an ordinance to include medical marijuana facility uses in designated overlay districts, and whereas Ordinance 2363, Section 2.546, Medical Marijuana Provisioning Center, Section F, licensing, states that no more than 5 provisioning centers shall be established in each of the medical marijuana overlay districts, including Cesar Chavez, Walton Boulevard, and C-2 downtown overlay districts. And whereas Ordinance 2363 states that no more than 5 provisioning centers shall be established in the C-1, C-3, and C-4 zone properties combined outside of the medical marijuana overlay districts. And whereas the city clerk accepted provisioning center applications by overlay districts and the non-overlay for a 21-day period, January 6th through 27th, 2020, and whereas the city clerk ranked and scored provisioning centers by district using a 130-point scoring system, and whereas the city clerk informed Nature's Remedy of Pontiac that their application for a provisioning center in the Walton Boulevard overlay district had received a score of 116 and a ranking of 5 of 15 on November 24th, 2021, and whereas based on the hearing officer recommendation and other appeals in the Walton Boulevard overlay district, your ranking changed from 5 to 8, and whereas Nature's Remedy of Pontiac appealed the score and ranking to the city clerk because it was no longer ranked in the top 5 for the Walton Boulevard overlay district. The city clerk appointed Grewal Law PLLC to serve as the hearing officer. The hearing officer conducted a hearing on January 21st, 2022. The hearing officer issued a recommendation to the city clerk. The city clerk adopted the hearing officer's recommendation. Based on the hearing officer's recommendation and other appeals in the Walton Boulevard Overlay District, Nature's Remedy of Pontiac ranking changed from 8 to 6 and remained not ranked in the top 5. Therefore, the city clerk affirmed his decision to deny Nature's Remedy of Pontiac application, and whereas ordinance 2357B allows an applicant to further appeal to the Medical Marijuana Commission, and whereas Nature's Remedy of Pontiac submitted their appeal to the Medical Marijuana Commission on February 25th, 2022, and whereas the city attorney issued a recommendation to the Medical Marijuana Commission to deny Nature's Remedy of Pontiac appeal, and whereas the Medical Marijuana Commission reviewed Nature's Remedy of Pontiac appeal and the city attorney's recommendation, now therefore be it resolved, the Medical Marijuana Commission finds no basis to overturn the clerk's decision to deny Nature's Remedy of Pontiac application for a provisioning center in the Walton Boulevard Overlay District. Can I get a motion to move on this?
Motion to take action.
Can I get a second?
Second.
Okay, then moved by Porat.
Yes.
And second by Wilson.
Sorry.
City clerk, roll call.
Ford,
Yes.
Wilson,
Yes.
Maley, Pratt.
Yes.
Thank you. We are now down to public comment. Anyone who want to come to the podium, you have 3 minutes to speak. We ask you to identify yourself and your time will begin.
Good afternoon, everyone. My name is Johannes Bose, citizen of Pontiac, business person. Hello? Can you hear me? All right, so my name is Johannes Bose, citizen of Pontiac, business owner, community activist, advocate for youth. Had a few questions real fast. One to ask, one more likely, someone told me to ask, but one likely because Mr. Doyle is pretty thorough. Was new gentlemen sworn in? Have they been sworn in yet? And, first of all, main thing, last I checked, Pontiac is the equal opportunity city. And we got females here. This don't look good, all males. Look like an old boys club. All right, so I need to get some females up there. There's another cheer over there. And we got plenty of candidates, a lot of smart women around here, professional, old and young. So that's something needed to be looking to. Also, I see it's always been for, if you know, I don't know too much. I just sit on boards of local, state, city-wise, and national. If you're going to have a board, even though more than likely tiebreaker is probably by someone from the city, you need to have 5, or always odd, something that's odd, and have someone that's not in a paid position that's going to have the best interests of the city of Pontiac. Also, has anyone yet so far won an appeal? Sound like lip service. And these gentlemen here, you all are pretty new, so either you all should abstain from voting or ask to set aside and come back until you can review the information that you're doing. You know, you come in and y'all just write in and y'all voting on different stuff that more like you, I don't know if you're familiar about, but hey, you might be, but I'm just observing. That right there. Oh, as far as on the community impact, can't speak on everyone else, but I can speak about Flourish, Michigan, on the nature community impact. Even though they're in the review process and they're doing a lot of different things, they're still out here doing something for the youth and the other people in the community. So back to, like I said before, the people that's in our city come to get money out of our city. should be doing something for the city, and out of a fair process, it shouldn't be a monopoly. You know, we shouldn't have 1 or 2 or 3 business owners with 2 or 3 licenses. We had 107 people apply, so they should have gave everyone a fair chance. And even if some of those weren't in the top rankings, if a person was
It's your time, sir.
okay, be fair.
Thank you.
That's all I'll say. I'll see you next time.
Is there anyone else who wishes to speak? All right. Seeing or hearing none. Can I get a motion to adjourn?
Motion to adjourn.
Can I get a second? Okay, and motion been made to adjourn by Commissioner Porter, second by Commissioner Wilson. Roll call.
Wilson,
Yes.
Maley,
Yes.
Parath,
Yes.
Ford.
Yes. Okay, according to my clock, it's 7:02 p.m. and this meeting is officially adjourned.